going to go ahead and get started. Hopefully other folks can join. We have good participation. I want to thank everyone for joining us again. Good afternoon and welcome to Open Meetings Act and Freedom of Information Act Recent Advisory Opinion Review. I'm Neal. I'm the Chief Counsel at the Office of Open Government, and I am joined on this call by my colleagues from OG, including our Director, Neal Allen. We're also joined by the rest of the OG team, including Attorney Advisor Joan Lelma, Attorney Advisor Anthony Skirbo, Attorney Advisor Brandon Lewis, our Paralegal Specialist Kimberly Brown, and our IT Specialist Kevin Brown. So today we're going to discuss in depth 4 advisory opinions, and very briefly going to mention one more published by the Office of Open Government, giving you a brief background about each matter, the legal arguments at issue, and the director's rationale and conclusions. And hopefully you'll find these cases and the opinions interesting and enlightening. So again, I would like to, before I get into the meat of all this, I would introduce you to us. We are the Office of Open Government. I know that you have gone through a couple of our presentations where we went through all of the various aspects of who we are and what we do, but it is always interesting to repeat it. We are a relatively young agency as compared to many other agencies in the government, so it always bears importance mentioning who we are and what we do. I won't read it all word for word, but we've talked about that we are another agency under the Board of Ethics and Government Accountability. Our sister agency is the Office of Government Ethics. We're co-equal in that regard. We have our own director who issues advisory opinions pursuant to the relevant law relating to the Open Meetings Act. And she has has enforcement authority regarding the Open Meetings Act, as well as she has the authority to issue advisory opinion as it relates to the Freedom of Information Act. So we've also talked about our preamble. It is our public policy. It's something that we stand by as it relates to AOs for OMA or advisory opinions as it regards to FOIA. Our policy is a policy of the District of Columbia that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. Sorry about that. I actually had, okay, back. I'll ask, as the director asked earlier, nobody send me emails or text while I'm presenting. Again, this is our public policy, our preamble. We stand by it. We believe in it very strongly, and we do our best to practice what we preach in that regard. So now I'll talk about the advisory opinions that we will discuss today. There are, as I said, there are 5, 4 that we'll go into depth, and one that we'll do, as I call it very honorable mention and very brief, and I'll explain to you why when I get to that one. The first is DC Public Charter School Board and their compliance with OMA. FOIA advice concerning multiple extensions as it relates to FOIA request. An information OMA, an OMA case regarding the Counsel, the DC Counsel. Complaint regarding the FOIA request and the portal in the case of MPD and the Office of Unified Communication. And again, as I said, the one case that I will give honorable mention to. So the first case, now this is a complaint that we received back in February of this year. It's unique in that it is a singular complaint, but it alleges OMA violations by 47 boards of trustees for a DC Public Charter School. So while the collective complaint, which is this one, was assigned a singular matter number, the specific complaints against each of the public charter schools boards of trustees was assigned a subcomplaint number. This particular complaint only dealt with 2 issues. The first issue was There's a complaint concerning whether, I'm going to move here. I don't know whether you all are seeing the same thing I'm seeing as it relates to our boxes here. So I'll move those away. Actually, I can probably close that out. Sorry. So the complaints concern, as the complainant alleged, easier access to the public charter school boards of trustees meeting, and it was also concerned with the creation of board meeting templates that would be used and followed by all of the charter school websites. So now, by the way, uh, attorney advisor Joan Lelma investigated this matter for the director. Joan is our resident expert as it relates to our public schools and our public charter school matters. So when this matter came in and she realized that it wasn't just one matter, but it was 47 matters with differing issues that would need to be dealt with individually for the next 47 years or so, she thanked the director. She thanked us profusely for letting her be a part of this. Like every day, it's like, oh, thank you, director. Thank you, Lewis. We appreciate it so much. And like, stop. It's really getting pitiful. So just stop it. So anyway, so one of the first things that we have to do when we have these types of cases, when we investigate these cases, is we have to establish when we investigate any OMA matter is whether the entity that is the subject of the complaint is a public body and is obliged to adhere to the OMA. In this case, DC Charter School Boards of Trustees are public bodies as contemplated by the OMA. Excuse me, my slides are giving me all kinds of problems today, but we'll work through it. We'll be fine. All right. So there are other OOG opinions concerning the definition of a public body. OOG has issued several advisory opinions which have applied to a broad spectrum of the definition of a public body, task force being one, other bodies beyond boards and commissions that their work is intended to impact district operations and inform policy. These particular entities, they meet to consider, conduct, or advise on public business. Now, this interpretation, again, also applies when the public body was not necessarily established by a mayoral order or by a statute, but less formally by a subordinate office or agency. So if you have a public body that actually establishes subcommittees or task force, those two can also be considered public bodies. So let's get down to the pertinent facts regarding this case. We got an email. Somebody was unhappy, and they sent an email. They sent an email to OG alleging OMA violations against 47 boards of trustees. Their concern was, is DC Public Charter School Boards obligated under the OMA to monitor boards of trustees for DC public charter schools? And are they supposed to monitor them for ease of access to the public body's information? And are DC public charter school boards obliged to ensure a universal posting format amongst the boards of trustees on the DC PCS's website? These were the concerns. So as it relates to ease of access, the most important thing is openness. When we talk about the Open Meetings Act, we put an emphasis on open. Okay, unless it's specifically and legally exempted under the relevant code, all public body meetings that conduct business are presumed to be open. So this relates to the ease of access concern. How easy is it to access? Well, if it's open enough, it should be relatively easy to do so. The Open Meetings Act really favors openness and transparency of DC public bodies meetings. So we do recognize, though, that sometimes things change and schedules must be adjusted. And in those instances, the public must be given notice. So it's really all about notice, making sure that the public is informed. they're supposed to give notice for at least in at least 48 hours or 2 business days, whichever is greater, except as it relates to emergency meetings. So back to the complaint itself. So now we'll talk about 2 OMA rules regarding, first, the prescribed format for a public body to make a public body's meeting information available, that is, make it more easily accessible on its website. And then the second OMA rule, which says that a group of similar public bodies to conform to a specific website format, that has to be done that way. So those two OMA rules are non-existent. There are no rules in the OMA that necessitate either of those particular concerns that the complainant had complained about to us. In fact, the OMA is very silent on those particular issues. Very silent on whether a public body must make certain information easily accessible or its meeting information available on its website. And it's also silent on the issue of whether similar groups must conform to a specific website as well. So in those situations, is it hopeless? We have, what does the OMA concern itself with? Okay. There is one issue of formatting that the OMA does establish, and that is a public body is required to include a statement at the bottom of the public body's draft and final notice. And it says that this meeting is governed by the Open Meetings Act. Please address any questions or complaints arising out of this meeting to the Office of Open Government. You've probably seen that. And if you haven't, and it's not on any of the notices that you put out, then you should probably do that as soon as possible. So now if there's no guidance on either the issue of a particular format to which the public body must prescribe in making its meetings information available, and there's no necessarily any OMA guidance on whether similarly situated groups conform to a specific website format, then we really want to concern ourselves with what is the expectation and requirement for openness and transparency as it relates to meetings governed by the OMA. And here it is. DC Official Rule Section 2-573. It's our rules of construction. You heard Brandon Lewis talk about our rules of construction earlier when he presented his OMA presentation. And it says this subchapter shall be construed broadly to maximize public access to meetings. Exceptions shall be construed narrowly and shall permit closure of meetings only as authorized by this chapter. And as lawyers and as DC government employees who see this type of language all the time, it makes sense. We usually don't have any problem understanding what it means. But what if you are a cat lemur sitting on a box? What does that mean? What's the deal? So it means very simply, laws should be interpreted very generously and expansively to allow meetings to be as open as possible, and that any reason for closing meetings has to be interpreted very strictly. They can't be stretched, they can't be extended beyond their specific purpose. And when meetings are closed, they can only be so when the law explicitly permits it. So back to our complaint. The ease of access. So not enforceable. It's not enforceable under the OMA. However, DC Official Code 2-5762 does mandate that a public body does have to provide advance public notice of its meeting. The notice has to follow a particular rules. It must be provided, in the office of the public body or at a location that's readily accessible to the public, and on the agency's public website or the DC government website, which is our central meeting calendar. And it should look a little something like this. This is Bega's notice of meetings. This notice is posted conspicuously on our front door at our address at 1030 15th Street Northwest, Suite 700 West. It's posted. It gives all of the relevant information, where, when, And as far as any virtual considerations, we make sure that the meeting ID is on the meeting notice, any passwords, any phone numbers, or any other contact that would be necessary for someone to be able to effectively manage to get to our meetings and to view them. So back to our complaint. So if we're requiring, if we're concerned with whether there is DCPS public school board trustees have to institute a publication format in conformity with any similar bodies or similarly situated bodies, what does OMA say about that? Well, again, the OMA does not have any say so on that. Neither the OMA, and in fact, upon investigation, Joan investigated that even the enabling legislation of the DC Charter School Board does not require any of that formatting as well. So in those situations, we have to look elsewhere. Now, DCPS does have a particular policy. And one of the things that I think that public bodies often forget is that as much as we appreciate them looking to us, Office of Open Government, and the OMA for answers to a lot of different things, we remind them a lot of times it's their own policies and guidelines that often provide the answers to any of the questions that they must confront. So in this case, there was a public information policy by the school board, and there were prospective, yet unpublished but soon to be published guidelines concerning the universal formatting posted. And it said to ensure the public has accurate information, public charter schools must publicly post the documents listed in this policy to a single page on the school's website, no more than 2 mouse clicks from the homepage. And schools are responsible for posting and maintaining the website. Now, the director was very careful in pointing out in the advisory opinion that while DCPS's public information policy was a resource that they looked to for concerns for which the complainant voiced, it is not and it should not be confused with the requirements of the OMA, which of course do not necessarily require these things. So the director concluded that the complainant's complaint regarding easy access to the school boards of trustees meeting information and a board meeting template that DCPS schools would use on their websites don't raise any concerns which are violations of the OMA. So the director dismissed the complaint as related to those pertinent facts and circumstances, but not necessarily the other collective 47, which Joan is happy to continue to work with until the sun goes supernova. So our next case was a FOIA case by the Executive Office of the Mayor. So this case addresses the use of multiple extensions by the Executive Office of the Mayor in response to a DC FOIA request by the requester. So the particular concerns there, the requester wanted us to evaluate whether the EOM's decision to cope with delays was something that invoking multiple extensions to the request, if that was something that conformed with the law. Now, this FOIA advisory opinion was investigated for the director by attorney advisor Anthony Skirbo. Now, Anthony also happens to be OOG's FOIA officer, so he has a very intimate understanding of what EOM's FOIA officer was dealing with in this particular matter. Now, any of you who are FOIA officers know the volume of information that you have to weed through to fulfill a FOIA request can be pretty extensive. And in this particular case, Anthony had a litany of email communications between the complainant and EOM and the FOIA officer. He had to review all of the alleged notices of extensions. He had to review different letters which accompanied any of the documentation that the EOM FOIA officer had forwarded to him. He had to review the complainant's appeal to the MOLC. He had to review the MOLC's denial of that appeal, as well as many other documents and communications that were vital for the director to be able to make her determination. So as it relates to the laws regarding extensions and things of that nature, Section 2-532C1 says that except as provided in paragraph 2 of this subsection, a public body upon request reasonably describing any public record shall within 15 days, and that excludes Saturdays, Sundays, and public holidays, of the receipt of any such request, either make the requested public record accessible or notify the person making that request, making them aware that they're not going to be able to get it. So in other words, all things being normal, the FOIA officer has 15 days, excluding weekends and holidays, to make the record accessible to the requester, or at the very least, notify the requester that they won't be able to either provide the whole record or part of the record, and the FOIA officer has to give them an explanation as to why. Now, this, aside from being actual footage of Anthony 2 days after receiving this investigation, is another aspect of the law as it relates to time extensions and the time limit. This is section 2-532D1, and it says, in unusual circumstances, the time limit prescribed in subsection C1 and C2 of this section may be extended by written notice to the person making the request. Those extensions shouldn't exceed 10 days, except the holidays and the weekends. And for records requested under C1, it's 15 days, except those same excluded days. So we just talked about the time limit requirements, and that section 2-532D1 does provide for, again, these unusual circumstances and what those circumstances mean. So unusual circumstances, what are they? We can say, give a definition, but it's better just to say what those are. Unusual circumstances are limited to two things, basically. That is the need to search for and collect and to appropriately examine voluminous amounts of separate and distinct records that are demanded in a single request. Now, I say that because sometimes requesters make what they think are relatively simple requests, but they know not what they ask for oftentimes. And in doing so, they don't really realize that sometimes what they're asking for really is a lot more information than they think. And in those instances, the FOIA officer can invoke the unusual circumstances provision and say, this is just going to take a lot of time to get. So we need to invoke the extension. The other reason is for the need for a consultation. Every now and then, another government organization has a major stake in a decision that the director would make as it relates to filling a FOIA request. And in those cases, sometimes the FOIA officer has to consult with other agencies in order to do that. And sometimes it's even different departments within the same agency where there has to be some kind of a consultation, because that particular department may have a vested interest also in the release of those records and any exemptions that might apply. So in those instances, the FOIA officer can also invoke the extension. So the last rule as it relates to that, as any failure on the part of the public body to comply with this request within that time frame is deemed a denial. It's deemed a denial by law. It's considered denied, and in that case, that person making that request is deemed to have exhausted their administrative remedies with respect to that particular request, unless they choose to petition the mayor, go to the MOC to review the deemed denial of that request. So, some very quick run of this. Now, there are a whole lot of facts, as I explained earlier, but that we received this particular request back in September 23. They submitted a request to the EOM concerning the mayor's travels during a particular time frame. The FOIA officer in the mayor's office sent a request notification, sent the requester notification of a 10-day extension citing unusual circumstances, as we talked about a little while ago. And it was based upon the first rationale, voluminous number of records demanded by the requester, and they ensured the requester that there would be a determination and update on the status of the requester's request by February 1st. And then on January 31st, a second notice of extension indicating that EMO was exercising an additional 10 days and setting a new date for fulfillment of that record. So what happens next? Well, a whole lot of different things happen next, and I'm not going to require you to read through each one of those things. There are just a couple of things I'd like to bring to your attention. One was this request, this very first request that you see here on February 2nd, where the requester received an email from the FOIA officer stating they had identified emails in Teams and other messages, but they had not been able to review all of the text messages, all of the WhatsApp, and all of the other messages that were in other message applications. And so they asked the requester, would they be open to narrowing this portion? Now, one thing I want to bring to your attention is that sometimes and oftentimes FOIA officers, what their jobs are to be able to effectuate fulfilling these requests, but doing so in a way that may be a little bit wiser than what the requester thought. So it is within the duties of the FOIA officer to make suggestions about how they can fulfill the request of the requester, but also do it in a time that is less tedious, less burdensome to the agency. So it's kind of a win-win situation. So, FOIA officers often have to do that kind of stuff, and that's what this FOIA officer did. As you see, there are a number of things that occurred after that, including emails going into the spam box of the FOIA officer, and additional extensions being requested. So just any number of different things happened over the course of time that delayed the fulfilling of this particular FOIA request. However, on the 30th of May of that year, EOM did send the requester a letter stating that the documents responsive to their request had been delivered via the FOIA portal, and informing the requester that documents and portions of the documents had to be withheld pursuant to two exemptions, one being that there was information of a personal nature, where the public disclosure would constitute a clearly unwarranted invasion of personal privacy. And the other one was an invocation of the deliberative process privilege. And same thing again, still dealing with all of the issues that he's dealing with this case. So then what happened? So the sorry, with this. So EOM also in informing them that they had fulfilled the request and letting them know about the exemptions that applied. They also advised the requester of its right to appeal to the mayor of the District of Columbia, the MOC, or to the Superior Court for any other issues that might be involved, particularly as it related to the exemptions that they invoked. So there are a few things that the director had to analyzed as related to this particular case. So the first issue was EOM's notification to the requester invoking an extension to issue a determination. It did not comport with the requirements of the FOIA laws. Okay, this regulation requires that the agency inform a requester of their right to treat the delay as a deemed denial, as a denial of the appeal rights. And in this case, the FOIA officer did not include this information in the January 18th, 2024 notice of extension. In this regard, the FOIA officer's January 18th notice of extension, it did not comport with FOIA requirements. The second thing that the director brought to our attention was that EOM had failed to make a determination to dispatch requested records within the applicable time period. The specific citation was 1 DCMR section 405.5A, and it says that with the extension, the applicable time period for EOM to have issued a determination was 25 days, excluding those weekends and holidays. And since the requester's request was received on December 22nd, EOM was required to have responded by February 1st. And the third issue that the director analyzed was that the DC FOIA doesn't provide for the use of multiple extensions. Okay. And the fourth issue was the failure to provide a timed determination of the December 22nd request. It actually became moot once EOM did issue the determination, which it did. So there's case law to back that up. So that particular issue had become moot because the requester did eventually receive the information they requested. And so then there was no need to really analyze the failure to provide, because there was no failure. They received it, they just didn't get it on time. So the conclusion in this case is when the agency did not make a determination within the applicable time frame, 1 DCMR 405.5 provides that the agency must notify the requester of certain things. One, they had to notify them a reason, give them a reason for the delay. The second thing was the date on which a determination may be expected. They had to notify them of that. And they had to also notify the requester of a right to treat the delay as a denial and to inform the requester of the appeal rights provided by DC FOIA. Now, in this case, EOM did provide the requester with the reason for the delay and the subsequent dates on which determination might be expected. However, they didn't notify the requester of their appeal rights, which FOIA law requires. DC law, FOIA also provides for the issuance of only one extension. So while the FOIA law indicates that the agency may continue to process the request, the issuance of several successive notices of extension does not comport with DC FOIA laws and regulations. Okay. So ultimately, the director recommended a couple of things. She recommended that all future FOIA requests, EOM should adhere to the requirements, as we've already outlaid. That the EOM should ensure that not more than one notice of extension is issued in accordance with the law, and that when a determination can't be made within the applicable time period, EOM must ensure that requesters are informed of their right and to treat the delay as a denial of their FOIA. Okay, so on to our third case. This is a very brief one. This was a case concerning the Counsel of the District of Columbia. So a complainant alleged that the council chair and other council members, in what amounted to a quorum, attended a dinner at a restaurant and they discussed public business without giving notice to the public, which of course is a violation of the OMA. Now, before we go into violations of the OMA, I need to bring to your attention, just as Brandon Lewis did in his last presentation, there have been changes in the OMA. He outlined those changes, but I'll just kind of temporarily, I'll just quickly go over them again. There were bills. There was the Open Meetings Clarification Emergency Act, which actually expired on July 6th. And then there was the temporary bill. It went through, obviously, its legislative process, but ultimately it was transmitted to Congress on July 7th, and it became law on September 16th. So what does all that mean? The key takeaways from this particular processing of the changes in the OMA, the bill redefined what a meeting is. As it relates to the council specifically, a meeting is defined as a regular or additional legislative meeting where votes are taken. That's a meeting. The bill, now law, allows public bodies to discuss potential terrorist or public health threats in closed sessions if disclosure could endanger the public. The law, and excuse me, I had bill there, should have changed that. The bill provides more flexibility in the meetings and more access to allowing the meeting to be considered open if reasonable steps are taken to allow public viewing or hearing, or either during the meeting itself or as soon as technologically feasible. It creates a specific exemption for meetings between the DC Council and the mayor, provided that no official action is taken during those meetings. And it also modifies notice requirements for public meetings, making them less stringent by changing language from mandatory provisions to attempted to language. So rather than saying you must do this, now it says you must attempt to. What does that mean necessarily? We're not 100% sure, but that's what it now says. So again, it has already been established what a meeting is defined, what it was defined as, and now what it is defined as now with the new changes to the OMA. Meetings now are any gathering of a quorum of the members of a public body, including hearings and roundtables, whether they're formal or not, regular, special, or emergency, in which members consider, conduct, or advise on public business. Now, for the purpose of the council, the term meeting means a regular or additional legislative meetings and committee meetings where votes are taken. So a quorum, I always hear us talking about a quorum. We usually tell people half plus one, but basically it's the minimum number of members of a public body that can legally meet and conduct business. This is usually, of course, the majority of the members. And a quorum is determined by either as a simple majority of members, unless otherwise specified by law. And the number of members can vary based on the organizations, but quite often the organizations themselves set their own bylaws to determine what exactly a quorum is, or what the percentage would be. So public bodies. We've already described public bodies, but of course there are all different kinds. But this change in this particular law sort of changed what a public body is. Now, normally obviously it's any government council, board, commission, or similar entity, advisory board that takes action by vote. It does not include certain groups, such as the local courts and the ANCs. And as you heard the director say earlier in her presentation, ANCs may at some point end up coming under the OMA, first because everybody thinks they are anyway, and because we get such a large volume of complaints or inquiries as it relates to our ANCs. And now, of course, the Criminal Justice Coordinating Council, CJCC, as Brandon told you earlier, they are now exempt as a public. They're not considered a public body for purposes of the OMA. So a meeting is not. It is not a chance or a social gathering where no business is discussed. It's not a press conference. It's not an email exchange. And I believe a question was asked of Brandon during his presentation about business being discussed in email exchanges. And he made it clear, rightfully so, that no business can be discussed during, by members of a public body uh, through email exchanges. And in fact, had a very interesting situation happen at my last agency where I was at OAH, and um, I was arranging for coordinating a meeting of the commission, uh, basically just going and asking people their dates, uh, you know, availability, things, that they would, so that we would be able to establish a particular time frame for one of the commission meetings. During that email exchange, and it was back and forth, a lot of emails, because again, not available this day, not available that day. One of the members asked a specific question about one of the situations on the agenda or on the proposed agenda, and another person chimed in and answered that question. So what we were having was a bit of a discussion, and the general counsel at the time, who was also including, I was a deputy general counsel, she was a general counsel at that time, uh, jumped in uh, and said, "Stop, cut it out, don't say anything else." so so to Brandon's point, no, it's because then you may be violating the Open Meetings Act, because now you don't have a notice meeting, but you're talking about public business and maybe even making decisions, or at least you're deliberating and just having discussions about public matters that should be discussed in an open meeting. So yes, to that email exchange thing, yes, you have to be very careful with that. Also, per the amendment, meetings between the DC Council and the mayor also are considered not meetings provided that no official action is taken. So this particular investigation seemed to be fairly straightforward, given our understanding of the new OMA provisions. And it was interesting in that, I'm sorry, it was interesting in that um, in this particular case, the our director, being the renowned superstar of DC government that she is, felt cause to recuse herself from the investigation and then publication of the advisory opinion on this matter. So that responsibility was handed down to me. As it had been on a couple of occasions since I began working here. I'm always happy to know that the director has great faith in me and the rest of the attorneys and our paralegals. And as such, she's always given me very encouraging advice. And the most important advice that she always gives me is this. And so I make sure that that doesn't happen. Um, you know, and there's a provision that enables the director to recuse herself from certain matters. And in this situation, the chief counsel is authorized to review the matter and to issue a determination on behalf of the director. So, like I said, it was a fairly straightforward determination, one that I was very confident that I could knock out myself. But instead of taking that chance and remembering the director's advice there to me, I assigned it to Brandon Lewis to take care of, investigate, in case things went left. So then there was then our conclusion after investigating it, it was dismissed. Uh, the Office of Open Government may bring a lawsuit in the Superior Court of the District of Columbia for injunctive or declaratory relief for any violation of the subchapter. However, this does not preclude a private right of action. In this case, the aspect of the Open Meetings Act clarification amendment, so the amendments to the Open Meetings Act, clarified the definition of a meeting. And where the council is concerned, a meeting means a regular or additional legislative meeting, and committee meetings where votes are taken. So none of those things happen. So at this point, this legislation was in effect during that council meetings gathering, which was the subject of the complaint. Therefore, that meeting was outside of the scope of the definition of meeting where the council is concerned, and therefore it did not raise any issues within the Director of Open Government's authority. So in that situation, dismissed that case. So our next case. Wait a minute. All right. Thank you. So our next case was the Metropolitan Police Department and the Office of Unified Communications. This was a complaint regarding a DC Freedom of Information Act request and the DC government's FOIA portal and a constructive denial of that particular case. So the request in this case was the complainant wanted to know what accountability measures would be taken to make sure that request would be handled responsibly. And he also wanted a formal recommendation from the OOG. Again, the director may issue formal notice, formal recommendations, informal recommendations. We give a great deal of informal advice. People call in or send in quick emails, things that can be very quickly answered that don't require extensive research or long formal explanations. We do track all of those things as well. But in this case, this particular requester wanted a formal recommendation. So the complainant submitted a FOIA request, in this case, to Metropolitan Police regarding a police response matter. So after following up and informing MPDs of the complainant's accessibility barriers. There were some access issues that they had. And after the passing of many deadlines, the complainant received no record, had no confirmations that the report existed, and did not experience any coordinated assistance. So in situations like this, again, we've already discussed the deadlines as it relates to FOIA requests, 15 days excluding weekends and holidays. And in those situations, they have to inform the person of either provide the records, inform the person that the records are not available or they can't give them, or at least let them know that some records would be available, but others would not, and they would have to give reasons for why that was the case. So, as we stated earlier, any failure on the part of the public body to comply with the request, then the request is deemed a denial of the request. We literally just went through something very similar. And in that case, they've exhausted their administrative remedies with respect to that request, and they have to choose to petition the mayor as it relates to that deemed denial. So in this situation, we communicated with both the Metropolitan Police Department and with OUC. And those are budget reasons. We actually use that form of communication now. Although the complainant's request was constructively denied, records responsive to the complaint's request were identified, and they were fulfilled on or about June 11th, 2025. The complainant was informed that identifying specific steps taken by MPD and OUC or requiring dates certain are beyond the scope of OOG's authority, because that was something they were concerned with. They wanted us to identify what law required information about the steps that they'd taken, and require that they give you a particular date or a certain date when those records would be fulfilled. And the FOIA laws just simply don't speak to those particular things. Now, we already talked again about time and how time is always of the essence and can be quite a nuisance. So I won't go through all of that again. Again, it talked about unusual circumstances, which we have defined. In this particular matter, there was no indication that either MPD or OUC had requested an extension. So an extension request or the invocation of an extension in this case did not occur. So there was this relationship between MPD and OUC as it relates to the fulfillment of FOIA requests. The complainant informed MPD's FOIA officer on the deadline date that when there's no citizen complaint number, CCN number, provided when requesting the record, the process is to refer the requester to OUC to determine if a report exists. So you had these two different organizations working together, or at least have to work together in order to effectuate an investigation or of a particular complaint. And oftentimes this is because there is a particular number, again, this complaint number, the citizen complaint number, that's necessary. And if that number is not available when the person makes the complaint to MPD, then they now have to go to OUC to ask for a complaint number. And this is a process that they have. It can be a little bit tedious, but basically those are all the steps. You make a FOIA request for calls on service data, and you make that with OUC online, and then you submit that FOIA request in writing at the address for the OUC FOIA officer, and they would provide MPD Public Records Office would provide a number, a PD 251, which is an incident offense report, and then if reports are made, you submit. So I think you get the case, get the point. Is that there are quite a number of processes involved in order to effectuate getting the information that the FOIA requester was asking for. So this particular statute says that any person has the right to inspect and at his or her discretion to copy any public record of a public body in accordance with reasonable rules that shall be issued by a public body after notice. In other words, agencies may set their own protocols and processes for records requests, as you saw in the previous slide. Now, Anthony's research determined that while the requester did not receive the responsive records within the 15-day statutory period, it also appeared that the requester did not follow the process established by those agencies. Now, granted, the explanation of the process was not received by the requester until May 15th, which was the end of the statutory period. So in this case, it all amounted to the same thing. It constituted a constructive denial, and at that point, it was appealable to the mayor's office, just as in the previous case. Now, although DC FOIA establishes that agencies may indeed establish their own rules for DC FOIA requests, still, if you don't fulfill the request, then it's still violative. Okay, you've still broken the law, basically, and that that particular request is appealable. So, if your particular protocol happens to be a complex or convoluted one, and people don't follow it, that's irrelevant to the time frame requirements. So if you're not able to fulfill those records within the established time frame, according to DC FOIA, then you're still in violation, and now you have to invoke all the appeal rights information to the requester and the things that we've spoken about earlier. Also, a requester who's been destructively denied has the right to make an administrative appeal or seek judicial appeal or an injunctive relief from the Superior Court, whether the requester believes the procedure as explained by the public body satisfies statutory or regulatory requirements. So, in other words, even the requester can't say, hey, you know what, their process was convoluted and confusing and I didn't understand it. Doesn't matter. You've still been constructively denied, but you do have rights to appeal that denial. So there is, again, as I discussed earlier, there was an issue of access. The requester addressed the issue of access challenges due to a disability. They asked whether blind residents can submit FOIA requests independently. And by independently, Anthony's research kind of determined that the requester was asking whether submission of a FOIA request was achievable independent from any requirements to utilize the public portal. As for the accessibility failures, the requester was referring specifically to the CAPTCHA audio function on the portal, and that it had repeatedly failed to load or to function properly. The director informed the requester in the advisory opinion that the DC FOIA portal is overseen by the Office of the Chief Technology Officer, and that any issues regarding that would have to be addressed with them, and that any other issues as it relates to access would have to be directed to the Office of Disability Rights. They are the folks who are concerned with and enforce matters, including compliance with the Americans with Disabilities Act. The director copied both the agencies on that advisory opinion. So the conclusion of that particular case, 3 issues. There's a failure to produce responsive records within the statutory period as a constructive denial of a FOIA request, which is violative. It is in violation of the FOIA law. DC FOIA establishes that agencies may establish rules for DC FOIA requests. However, failure to fulfill a proper request is still violative and appealable. And finally, users with accessibility challenges due to disability have multiple options for submitting a DC FOIA request other than the portal, although compliance issues regarding government technology is the province of bodies other than the OOG and all of those folks whose matters those more directly or more appropriately involved. The director did CC and copy those folks as well on the opinions. So this was the case, and we have a couple of minutes here, so I'm going to get through this very, very quickly. This was the case that I said would have honorable mention. Now, there are 2 reasons why I want to mention this case. First, I wanted to bring attention to another case that was investigated by Brandon Lewis, and one in which he was not being used by me as a possible scapegoat if things went wrong. I want to talk a little bit about another aspect of the director's duties, or rather her discretions. We know that she may publish advisory opinions, and in certain instances, she may even bring a lawsuit in Superior Court. But she may also choose peace. Okay? She can sometimes direct, she can get complainants and public bodies to just sometimes chill. She can get them to relax, and any issues that they're dealing with, she can, let everybody breathe, and then bring folks to the table to try to determine ways forward. Now, this is an aspect of her job called conciliation. Now, this particular case wasn't a conciliation in the strictest sense of how it's defined, because conciliations usually take place in lieu of an advisory opinion or litigation. And of course, an advisory opinion was issued in this case. But in this particular case, there was a violation with regard to how closed meetings process. And the bottom line was an advisory opinion was issued, but the director and the chair of the zoning commission, along with his staff and us, managed to get together to help to rectify that situation. And that was something that was very largely facilitated by Brandon Lewis. He actually went over there several times, spoke with a lot of people. The director herself actually met with the folks over there. So we're not just about issuing advisory opinions. We're actually about getting our hands dirty in there sometimes and making things happen, making changes, helping people to become compliant with the laws and the rules. And so that's another part of what we do. Before I end, I also want to mention that the investigation of a lot of these cases involve not only a great deal of work by the attorneys, but also our paralegal, Kimberly Brown. Her skills are vital in helping me and the attorneys to get the information we need to transmit to the director in order for her to make her decisions as it relates to these cases. So right at the moment, right on time. Thank you all very much. This concludes my presentation. I believe there were some questions that were being asked during the presentation. I hope they were answered. And any questions that were not answered, please feel free to contact any one of us. Our information has been given several times there, so please feel free to utilize it. Ask any questions that you might have about this particular presentation or anything else that may come to mind. And this concludes our presentation and my aspect of the ethics week. So enjoy the rest of your ethics week's presentations, and thank you very much for your time.